So what's going on here?
In Your Honor, I'm sorry, 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 sorry. To the victim, I'm sorry, 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 sorry.
Hold on, that kind of slaps.
In Your Honor, I'm sorry, 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 sorry.
Anyway, what's happening here is that this guy's been convicted of armed robbery, and now he's at his sentencing hearing, which is where the judge determines how long he'll actually go to prison.
During these hearings, judges often allow defendants to make a statement to the court where they can explain themselves, say they're sorry, and basically ask for leniency. This guy apparently thought he was in a Disney movie and decided to sing instead.
Not sure that plan actually worked, because reports say that he was sentenced to more than 3 years in prison.
While this video has recently gone viral again, this courtroom ballot actually took place back in 2016. The man has since served his time and been released.
And in some uplifting news, he does appear to be crime-free and is still making music.
Now all these demons harm me. And to the victim, I'm sorry. Mama, I'm so sorry.
Honestly, it does kind of slap. It's January 1st, so police can no longer pull you over and ask, you know why I pulled you over?
Well, at least that's a law in California, although other states are considering similar laws. Basically, rather than police asking if you know why they pulled you over, they must now tell you why they did.
Of course, police can still question you, but they now have to lead with the actual reason for the stop first.
Supporters of the new law argue that it will help reduce pretextual stops, which is when an officer stops a vehicle for something small, but technically still illegal, with the hope of actually uncovering a larger crime.
Although some departments claim they no longer use pretextual stops, the Supreme Court has ruled that these are actually legal. For example, imagine you're pulled over and the officer asks, you know why I pulled you over? And you're an idiot or you don't follow this channel, so you admit,
Oh, well, probably because I ran that red light a few blocks back. Sorry about that.
even though they really only pulled you over for failing to use your blinker. You've now effectively confessed to running a red light. And interestingly, Miranda rights don't apply to simple traffic stops.
Supporters of the law further argue that it will improve relations between citizens and police, because the question
You know why I pulled you over?
is frankly just annoying and patronizing.
No?
Just say it like a normal
Oh, come on, I gotta be silly. Employees at a sporting goods store were fired for a reason that might surprise you.
So these employees were selling a pistol to a customer, or so they thought. The customer actually snatched the firearm and ran out of the store.
Because stealing guns is, bad, 3 employees chased the thief all the way to the parking lot. But they lost sight of him and he got away.
A few days later, upper management fired these 3 employees. Not because they were too slow, but rather because they decided to chase the thief at all. The store's internal policy on loss prevention states that employees are not allowed to chase or physically subdue any shoplifters. And that's actually a really common policy.
Companies have pretty universally decided that they rather just accept the cost of lost merchandise than risk lawsuits from employees trying to stop shoplifters. Because the employees could get hurt, leading to workers' comp claims, or even the shoplifter could get hurt. And as ridiculous as it might sound, shoplifters have been known to sue for getting hurt while stealing.
Whether or not you agree with it, that's the logic here. What's interesting though is that these job policies are actually different from the law. Although companies don't want employees stopping shoplifters, most states do give employees the legal right to do so. This is called the shopkeeper's privilege, which generally applies as long as these criteria are met.
This is a good example that your job's policies are not the law. And employers can fire your ass for doing something even if it's technically legal. Like calling your boss a big fat stinky poo-poo face.
Long list of people connected to Jeffrey Epstein is set to be released today, like probably right now. And people really want to see it, with controversy and speculation already running rampant online.
But first, let's back up. So this list includes around 150 people who were named in court documents in a lawsuit filed by one of Epstein's victims several years ago. In the lawsuit, the documents name tons of people as alleged Epstein associates, co-conspirators, and even victims.
But the actual names have always been kept secret, replaced instead with pseudonyms like John Doe 21 or Jane Doe 10. That's because the judge in the case decided that the privacy of the individuals named in the lawsuit outweighed the public benefit in knowing those names.
In other words, the backlash against the people named in the lawsuit would be worse than the good done by releasing the name. This is basically just a privacy balancing test, and it's common in a lot of trials.
However, the Miami Herald newspaper didn't like this and really wanted to see those names. So they sued to have the names unsealed, arguing that there was a huge public interest in knowing these names that outweighed those individuals' right to privacy.
And last month, a federal judge disagreed with that first judge and instead agreed with the Miami Herald and ordered the release of the name, which starts today and will continue on a rolling basis.
Now, as lawyers, we do feel obligated to mention that just because someone's name was included in these documents doesn't necessarily mean that they did anything heinous.
Maybe they did, but also maybe they didn't. Quick update while we were editing this video, 2 of the Jane Does appealed this order, so their names won't be released yet. Merry Christmas! Is it actually a crime to fart on someone?
And I'm out.
People have asked.
No one's asked.
So the most likely criminal offense here would be battery. And I actually found one case where someone was charged with battery for farting on someone. Enter Jose Cruz, a steel worker from West Virginia, who was pulled over at night for driving with no headlights. He ended up failing 3 sobriety tests and was taken to be breathalyzed and booked at the police station, where, according to court documents, he passed gas and fanned it with his hand at the police officer who arrested him, stating, "Here, put that in your breathalyzer," to demonstrate No? The court documents go on to explain that the gas was very odorous and created contact of an insulting and provoking nature. Cruz, for his part, admitted to weaponizing his fart. But okay, how is this actually a crime? Well, battery simply involves intentionally making harmful or offensive contact with someone else. That's really it. It's a super broad crime. And in this famous case, the court held that intentionally blowing cigar smoke at someone's face can constitute battery. So it stands to reason that blowing butt smoke could also count. All that said, while Cruz was charged with battery, prosecutors ended up dropping the charge while still pursuing that DUI. A 10-year-old boy in Mississippi was arrested for peeing in a parking lot.
Seriously? Our last video was about farts.
This one's actually important. Anyway, reports say that the boy was waiting for his mom in the car in a parking lot and had to use the bathroom. But he couldn't find one, so he chose to just go outside beside the car.
A passing police officer happened to see this and approached him. This first officer went to go find the mom and just warned both of them that he couldn't be peeing in public.
Fair enough.
But then other officers showed up and one of them insisted on arresting the boy. And so he was put in the back of a police car and brought to the police station to be booked, which included being placed in a jail cell. The boy then entered a plea bargain with prosecutors and the judge gave him 3 months probation. And also signed him a 2-page book report on Kobe Bryant for some odd reason.
So, yes, urinating in public is illegal, but police always have the discretion to not enforce the myriad laws we all break every day, and many believe these officers should have used that discretion here.
In fact, the arresting officer has actually been fired for violating the department's policies on dealing with juveniles, and the boy's mother argues that his race played a role in choosing to arrest.
But it's very important to understand that it wasn't just the police choosing to arrest a 10-year-old boy. Prosecutors also chose to actually file these charges and proceed with them, and the judge also chose to hand down a sentence.
It's important to understand that in the criminal system, there are 3 levels of power, and all 3 of them have the power to say, meh, this case is pretty dumb and I'm not dealing with it.
And many think it was dumb to actually arrest, charge, and sentence this boy, considering that Mississippi has much more serious crime it could be focusing on. Like, for example, the highest murder rate in the nation.
Just like Colorado, the state of Maine has also just announced that Trump will not be included on their presidential ballot because, according to them, he engaged in an insurrection on January 6th. And under Section 3 of the 14th Amendment, he is now disqualified from being president.
But what Maine and Colorado have done here doesn't actually mean anything yet, because this issue will ultimately be decided by the Supreme Court. And their decision here, whether or not states can ban Trump from appearing on their ballots, will be one of the biggest rulings ever.
I feel like that's happening a lot lately. Anyway, these are some of the main arguments that the Supreme Court will consider. First, Trump has never been criminally convicted of insurrection, and so his supporters argue that he's entitled to his due process rights before being banned from the presidency.
But on the other hand, Section 3 doesn't explicitly require any criminal conviction, just a finding that an insurrection occurred, which both Colorado and Maine have determined for themselves. The Colorado case in particular laid out more than 100 pages of evidence and testimony to support the claim that Trump incited an insurrection.
Second, some legal scholars believe that Section 3 doesn't actually apply to the president, and they also believe that the 14th Amendment, read as a whole, says that only Congress and not states can disqualify the president.
Both of these are huge controversies, the details of which will bore you. And all this said, the law isn't immune from politics. If you believe that it is, I have a beach house in Idaho to sell you.
Got a beach house I can sell you in Idaho.
And the Supreme Court currently skews conservative, with 3 of the 9 justices actually appointed by Trump himself.